Today, we're going to talk about one of the most horrific and disturbing subjects that we encounter in estate planning and estate administration. I'm going to start with a trigger warning. If you don't like discussions of violence, if you are disturbed by horrific situations, or you simply don't like heartbreaking endings, then you may want to pass on this video. But I must tell you that this is a very important subject. We have to, in doing any type of planning, consider carefully the worst case scenarios that occur, the details of what can happen when heirs or children find out about an estate plan with which they disagree, and how violence and even death are sometimes the result comes after the introduction. So we're going to start our discussion with a case that was reported in the Daily Mail on September 14th, 2024. I'll include a link to the written materials that accompany this particular video so that you can see the entire context. The story is regarding Joseph DeLuca, and I may be mispronouncing his name, and if I am, I apologize. He's aged 59, was aged 59, from Long Island. His mother, Teresa DeLuca, had left her home to be sold and the proceeds divided among her children, leaving Joseph, who had lived there his entire life, without a home. The will specifically instructed the executor of the estate to take whatever steps were necessary to remove any occupant of the home in order to facilitate its sale. His siblings had traveled from out of state for the funeral, and they sought to resolve the disposition of the home at a family meeting while everyone was together. Despite reassurances from his siblings, Joseph believed he was being left out of the estate, struggling with mental illness, grief, and the loss of his mother. Distressed about losing his home, Joseph opened fire during the family meeting. He used a legally purchased shotgun to kill his three siblings and a niece before killing himself outside the home on the front lawn. Neighbors and police noted his declining mental state. Authorities revealed that Joseph had dealt with mental health problems throughout his life, but there was apparently no episode of violence, at least as of the type that might cause someone to foresee this terrible tragedy at the DeLuca home. He was somewhat of a recluse and a hoarder, which only worsened his isolation. And despite the family's efforts to resolve the situation, his deteriorating mental state led to what is a tragic outcome. The home was reportedly worth about $700,000, and there was no indication whether there were other assets in the estate or what their worth might have been. Now, there's two things that I want to highlight in this story before beginning a more general discussion of what we can learn from such a tragedy. First, it's unlikely that Joseph would have been left homeless. Joseph was not left out of the estate. He was getting an equal share with his siblings, and it's reasonable to assume that he would have found some level of housing somewhere in the future. In other words, perceptions and emotions are often quite unattached to reality. It was his perception and his fear that drove his actions on that fateful day. Second, while the language in the will directed the executor to take whatever steps may be necessary to remove an occupant is unusual in a will, the effect of the language would have been the same without it. In other words, without the language, an executor would have had the authority to evict an occupant through legal process. I've had to do this a number of times when children would not leave a home that was necessary to be sold in order to allow administration. I'm not suggesting that the language in any way caused or contributed to cause the tragedy, because quite frankly, there's no way to know. But given that we can never know the consequence of language directed at or seemingly directed at any specific person, it's generally best to blunt the possible effect by avoiding such language. The general rule is to avoid harm, even emotional harm. That is why often in estate plans, we include statements of love and affection, even if we are excluding people from the plan. Or sometimes we'll have explanations or letters that provide reasons why a person has made particular decisions. Many of my clients include these explanatory letters drafted specifically to the people that are excluded as a way to know that it was them who made those decisions. Of course, no one can know whether any of these help. That leads to an opposing concern that clients will sometimes raise, and this may have been the reason for the language in the will. Someone will tell me, I don't want a sibling to blame another sibling for a decision that I've made. I would rather they blame me. I'm gone. In those cases, I'm often asked to include language to make clear that the responsibility for any adverse or unfortunate event, at least what might be seen as adverse or unfortunate, was the decision of the deceased, and so that it is clear. The cases that we just discussed, of course, represent one where the deceased is taking responsibility by the terms of the will. That may be why it was included, was to specifically indicate that it was mom who made the decision and not the children. Of course, it did not prevent the tragedy. When people tell me that this type of thing can't happen because their children will understand, they'll communicate well, they'll all agree, I have to just say it's not always true. Because although it may be clear to you and it may be clear to some of your heirs, it may not be clear to everyone. And grief and fear are strong, strong emotions, and they can compel these types of things to happen, especially coupled with an underlying mental illness or condition or drug addiction. Well, the reality is these types of things do happen. Lest you think it's unusual, I've actually encountered these types of situations 2 or 3 times in my practice. In the most horrific incident, a child who had recently returned home from prison was going through his family's home and found an estate plan. He looked through the estate planning binder and he discovered that he believed he had been excluded from the plan. The reality was that his share, because he was in prison, was being held in trust for him, so that while he was in prison or while he was under the consequences of his imprisonment, such as restitution orders, that his assets were not available to third parties and were safe for him, administered by a family member. In his situation, he reacted badly, and later he returned to the home to burn it down with his 2 parents inside. Like in the DeLuca case, he wasn't disinherited at all. It was his fear and his perception that caused the event. And there's absolutely no way we can know exactly how to deal with that. You don't find a lot of guidance when you read about estate planning or attend estate planning seminars about how to deal with these types of situations. In fact, when I was doing research for this particular video, I found very little in the way of true guidance with regard to what you might do. I'm going to link to some of the articles that I did find in the written materials that accompany this article, mostly involving troubled children or troubled heirs or challenging heirs. But what I think you'll find if you review them is there is a preoccupation with the assets, how to manage the assets, how to make sure that the assets are saved, how to direct the trustee or executor with regard to protection of the assets. There's very little in the way of managing the situation or managing a disturbed individual included in any of the materials that I've gone through. So what I did for the purposes of this video is I kind of went through what would be my decision-making tree if someone advised me that there might be this type of possibility. And the only thing I can commend to you is to, as a planner or a person doing their own plan, as a layperson, that you plan for the worst case scenario and you at least give consideration to each of the things I'm going to outline in how I might approach this situation. So let's talk about some of the things you should consider. The first thing I'm going to talk about is considering communication with your family. Now, the modern approach to communication with the family is that you should communicate everything with your family. Let them see the estate plan, give them copies of the estate plan, sit down and have a family meeting and let them know everything that you're doing. And of course, I have conducted those meetings. I have post setting up a trust or setting up an estate plan, conducted a Zoom meeting with the entire family where everyone is advised as to how the estate plan works, and they can ask any questions that they have. And in many cases, that works out really well. I have to tell you that I am a big believer in the value of communication and transparency, particularly where there are situations where there might be disputes. I am, however, a little troubled by how cavalier the modern approach is recommended. There are some things that should be considered. First of all, it really doesn't put any weight at all upon what the privacy interests or sensibilities of the person doing the planning are. At the end of the day, most parents don't want their children involved in their financial affairs. Most parents don't communicate to their children what they're worth or how they invest their assets or their money. And while I value the objective of open communication, it obviously offends at least some people's sense of privacy. Secondly, I don't necessarily believe that comprehensive communication is always the best thing. I'm kind of the opinion that you should communicate only that which is minimally necessary for your family to know that you have an estate plan and know where they can find the documents that are necessary for them to make decisions. There's a couple reasons why I think that that's probably the best case in most situations. The most important is the fact that when you communicate anything regarding your estate plan, you are going to create a reaction. And that reaction may be gratitude, but it also may be negative. There have been numerous instances in which people have been advised of an estate plan where they acted negatively. In one example I can give you of a client told his son, his oldest son, that he and his wife were leaving their estate equally to all of their children, and they had settled a trust. And the son was upset. He was upset because he had done a lot for his parents, and his two siblings had done very little. In fact, he felt his two siblings had taken from his parents much in the way of loans, education financing, getting on their feet, while he, as the oldest, was very low impact on his family's wealth. He felt, therefore, that he should receive a larger share of the estate plan. And when his father suggested that that isn't what they decided, he simply cut him off. Now, if estrangement was something that only affected a child and two parents, perhaps you could be cavalier and suggest, well, that's what happens, and maybe the parent should consider leaving even less to the ungrateful child. But the problem is that that's not always how it works. In this particular case, it also meant that the grandparents were separated from their grandchildren. And for a number of years, almost 12 years, this estrangement lasted. And it impacted really the relationship between all of these individuals. Quite frankly, if the discussion had never happened, perhaps there wouldn't have been the reaction. If he'd have only found out what his parents had decided after they passed away, well, there would still be a consequence. He still would be unhappy, but that consequence would not have been borne by my clients. Another reason that I don't like communicating everything is that it can also make later decision making more difficult. You may be reluctant to change something that you've communicated to other individuals. So an example would be that if you advise a child that you're picking them to be your trustee or your healthcare decision maker, but later circumstances are revealed, or you learn something, or just the situation changes, that there's a better decision maker. And now you feel reluctant because you don't want to offend that person, having indicated that you've chosen them. That may later seem like you've slighted them, that they've done something to disappoint you. And sometimes that's not the case. So if the situation occurs that you've communicated all of your decisions, you may find yourself wed to those decisions, even when it may be best for you to reconsider them and choose different people to make decisions. Same thing can be true with regard to disposition of assets. If you've suggested that something's going to happen, don't you know that a person that doesn't see that occur at the time of your passing is more likely to contest or challenge the distribution of the estate because you had promised them something? These advanced communications sometimes can be very frustrating with regard to how things work. Finally, communication invites intentionally or unintentionally input and advice. Perhaps you want advice and input, but perhaps you don't. More importantly, once invited, don't be surprised if there is mission creep. Suddenly, your family may have interest in other aspects of your life, and having invited them, it may be difficult to disinvite them, to tell them to mind their own business. This is all possible even when families are well integrated, they get along, they're all deferential to each other and to you. But it's more consequential if they're not well integrated, if they are hostile, if they bear grudges, if they're self-interested, selfish, or if they're simply money hungry. The consequences can be much more dramatic. If you have a family meeting, consider a safe place. Consider also the timing of any type of family meeting. And I'll discuss this a little bit later, but sometimes a family meeting immediately after death or immediately before the funeral may not be best advised. One of the things I think that is amazingly underutilized as a strategy is simply securing your estate planning documents so that they're not available during your life, especially if you've chosen not to communicate the details of your estate plan. This used to be common, that people would take their will or their trust and they would put them in a safe deposit box for safekeeping. That's fallen out of favor in large part because opening a safe deposit box in some counties and in some states is very difficult. Accidental or unintended of your decisions is protected, but they're not available if they're needed, particularly in a crisis situation. You can do this by depositing your estate planning documents with a lawyer, but I don't recommend it. Especially if you're using a lawyer like me who is a solo practitioner, you have to consider how available your documents will be if your lawyer dies or is unavailable. I'm probably not the best repository for my clients' estate planning documents because, as you can probably guess, I might die. And although I have a wife who runs my practice, who is much younger than me and much healthier than me, most solo practitioners don't have that type of relationship. Most solo practitioners don't also have an attorney. They have chosen to take over their practice in the event of their untimely death. I have. The reality, though, is that you're still entrusting a lawyer, a third-party professional, in just one office with regard to the originals of your most valued estate planning documents. Even large firms disappear, for one of a more complicated description of possibilities, and what happens to the documents that they draft in such cases is always unpredictable. There's an alternative, and that alternative is a program called Legal Vault. Most of my clients are given at least rudimentary information about Legal Vault. Legal Vault is, and by the way, there are other programs such as DocuBank that do the same thing. If you investigate Legal Vault and find that you don't like it, you can always contact our office because we have several of these programs that are available, and maybe one fits your needs better than another. I prefer Legal Vault because it's one of the easiest to use, and it actually does a couple of different things. The storage services started with the idea of making medical documents, your healthcare power of attorney, your living will, maybe donation of your organs and tissues, available to doctors and hospitals literally immediately if you happen to be presented there in an acute situation. They later expanded these programs to include legal documents. You can vault your healthcare powers of attorney and your will and your trust and your general durable power of attorney, really all of the documents, your deeds, anything you want to put into the vault. And then it's provided to, in the case of medical documents, to your doctors and hospitals when it's needed. It's provided in a secure storage, so it can't be lost, it can't be stolen, it can't be destroyed. And it can't be accessed during your life by anyone that you haven't given access to. In fact, in Legal Vault, I don't have access to my clients' documents unless my client's consent. Once they've created the legal vault, if they don't want me to be able to access their vault, they simply exclude me from the list of people that can access their vault during their lives. Now, the way the healthcare part of it works is that if you're in a situation where a hospital or a doctor has a need, they simply request the documents through communication mechanisms that the healthcare industry is readily familiar with. They do the same thing to obtain medical information from your primary care doctor when there's an acute situation. The first is the way that you go about helping facilitate that communication is letting your primary care physician know that you're using the program, so it becomes part of their medical records. The second thing you do is you carry around a durable card. So if you're in an automobile accident, for example, and they're going through your wallet, they're going to find one of those cards, and that's going to direct your medical records to that person. It's going to tell them how they can get your medical records, any of your medical conditions, your history, medications that you take, any allergies you have. That can all be provided through this program. For those who may be worried, it is HIPAA compliant and it's secure in the same way that your medical records are secured. And as I mentioned, one of these companies, Legal Vault, actually used to do HIPAA compliant documents only for the medical industry. And they moved over to the legal industry because it made sense. So you use the same systems of verification to determine that people that are requesting the documents are in fact medical professionals before documents are ever released. What that means is if you happen to be on a trip, going in your car or in a recreational vehicle and you have an accident in a small town in Idaho and you find yourself in a situation where they need to make decisions quickly, they can quickly learn about your healthcare decisions, your conditions, your medications, and also your decisions regarding end of life, allergies, special needs, requirements, basically the whole kit and caboodle. Of course, they'll also know who are your healthcare decision makers and how to contact them so they can quickly get in touch with them. Not having that information can sometimes be a health-threatening type of situation. That's the healthcare side of it. Your legal documents are handled a little bit differently. Your will, your trust, your powers of attorney, these documents are only available to third parties that you've identified, meaning your successor trustees, your executors, once they have established through their program that you have passed away or you have been deemed incompetent or incapacitated. Access is attained by providing them with a death certificate or a certification of condition. Once a death certificate is received, they'll release those documents only to the persons that you've designated in your legal vault, who are usually, as I mentioned, your successor executors, your trustees, or the executors of your will. All of this means that these documents are secure and available in whatever way that they may be needed in the future. The nice thing about a vault, though, is it isn't limited to just your legal estate planning documents. It can include all kinds of things. I have folks who use their legal vault for family pictures. I'm considering using our legal vault for our genealogy, which my father worked very hard to compile. I have clients who keep their copyrights and their copyrighted materials in their legal vault. Legal Vault currently has no space limitation. That may change in the future, but as a result, it's a very good place that you can store valuable documents and information. A legal vault is something I think more clients should use because it prevents the most common way that these types of incidents often occur. That is, when a family member goes through a home, discovers a document that they may not fully understand, draws a wrong conclusion, and then acts out. Obviously, Legal Vault is no help in a situation as what we talked about with the DeLucas, because that's a situation where he actually not only had the legal documents available, but the maker, his mom, had passed away and his family members were around him. So the truth is that having the documents unavailable wouldn't have prevented that particular situation. The next thing I would suggest is just general security. One of the things that I'm continually harping about with my clients is that they consider security in their home. Most of my older clients don't even have security systems. They still rely upon only their lock and key to secure their home and their belongings. I think that in the modern age, it's important to have a complete security system. Security system can help you not only from the standpoint that it can make sure that folks are not accessing your home and that your family members are not accessing your documents at home inappropriately, but it also secures your home from somebody threatening you or coming to you or causing you harm at a time when you are vulnerable. It also gives you a way to alert authorities. It's just a way to keep everything more safe and secure. And by the way, if you haven't investigated, many of these security systems today have either passive fall detection as a part of the security system or passive fall detection that can be added or incorporated in the security system. I think passive fall detection is the absolute best thing to do. We all remember the "I've fallen and can't get up" bracelets and necklaces. And of course, these are fine and absolutely invaluable for people that need them and will use them. The problem is that many people won't. They won't put on their bracelets, they won't put on the necklaces, and then of course there are situations where they can't activate them. Passive fall detection doesn't rely upon any of those things. If it's done by motion detectors with a security system or on a watch that you wear, like an iWatch, when the fall is detected, there's a notification. I personally employ an iWatch, but a Galaxy watch that has fall detection will work as well. I wear my watch most of the time because it has a much longer battery life than they used to, and that is probably necessary. I put mine on a charger when I go to bed. If you're a heightened fall risk, wear your watch to bed. And since it's waterproof, in the shower, and it will be there to detect the most likely falls in the shower and to and from the bathroom, particularly coming from your bed. You can charge the watch at dinner or at the breakfast table while you eat, and it'll be there for you for the rest of the day. Next topic I want to talk about is mental illness and grief. If you know you have a family member who has mental illness or is prone to experiencing grief profoundly, if they've made threats, if they you probably should report that behavior. I find that many of our clients are just hesitant to report them to anyone. They don't share them with a child's siblings. They don't share them with a child's spouse. They don't share them with counselors. They don't share them with their lawyer. Now, I'm not suggesting that you have your children arrested every time they pop off at a family meeting. Obviously, you want to have some perspective in these situations, but I do strongly recommend that you communicate these types of situations to everyone concerned. If nothing else, communicating them with counsel or other people can make a record of it and advise you and your successors whether maybe there's something that should or shouldn't be done. At least we can indicate that they shouldn't be ignored, the concerns shouldn't be ignored. I wonder how oriented were the family members of the DeLuca family, because they all lived out of town, and how well they knew the severity of their brother's mental illness. They may have only known tangentially how deeply disturbed he was. Finally, communication is another issue, and I'm going to revisit it because after death, there is going to be a family meeting. But first thing I would suggest is that the family meeting be done at a safe place, perhaps somewhere neutral, the conference room of a funeral home, a hotel, a banquet room in a restaurant. Someone storming out of a meeting is preferable to someone retrieving a readily accessible weapon and inflicting the type of carnage that we saw in the DeLuca case. Consider security. I recall years ago attending a distribution of personal property possessions at the home of a deceased, accompanied by a male paralegal who had military training, and the family had, at the event, paid security. Of course, all of this was demanded by bad behavior of one or a few of the family members. But other than horrendous comments and gestures, all of the pre-planning and work meant that the distribution was conducted peacefully and without any type of incident. Finally, I would suggest that whatever you do, get through the funeral before getting down to business. I know it is the convenience often compels people to make a decision like the DeLucas to do it while you're in town. This was my understanding is the meeting in the DeLucas case was actually before the funeral. It is at the funeral and in the days before and after that grief and impairment are most obvious. Use this time to heal and take care of each other. Stuff can wait. Sometimes just being deliberate and measured rather than rushing to get things done because it's convenient gives people time to settle. And if nothing else, it gives other people time to observe, assess, and protect those who are suffering. Regardless, letting your family know, letting your counsel know, letting advisors know, letting authorities know that a person is reacting badly or unexpectedly or especially criminally out of grief or out of desperation or mental illness or drug addiction before something desperate happens is important. Now, the last thing I'm going to say about this whole subject matter is that while I've discussed some of the considerations that I would advise for my clients, the one thing I want to be clear about is that I don't think any of these should be seen as a suggestion or an intimation that you should change your estate plan or that you should change your mind with regard to how you should treat your family or how you identify the objectives of your estate plan. You should not change them because of other people's possible threatened or intended or even expected behavior. In other words, if you want and you feel that it's important to disinherit a person, you should. You should not, as a result of possible consequences, include somebody that your heart and mind says you should not include. As you can no doubt tell from this discussion, including them doesn't always guarantee that there will be no drama. Talk to your legal counsel. Map out the best strategy to keep you and your family safe in the event that you're concerned. It is your estate plan. You're the boss, and you should do what you think is best. I would never condone somebody being coerced or intimidated, even passively, into an estate plan that they didn't agree with. In fact, legally, such an estate plan is not even enforceable. So you shouldn't put yourself in a position of fear or apprehension of such a magnitude that it changes your mind with regard to what the ultimate objectives of your plan are or how you accomplish them. By the way, this only underscores why it's important to have a relationship with an attorney or a counselor, a clergy person, or a trusted advisor. Maybe it's a friend, maybe it's your spouse, with whom you can discuss openly such topics. It is only by having an open relationship and a continuing relationship that you're going to feel comfortable broaching such topics and discussing good advice and options. If for no other reason than that, keep in touch with your close, trusted advisors. Hopefully you found this material valuable. Hopefully you didn't find it too disturbing. If so, please like and share the video. In the meantime,